Hi, I'm Denise. I'm a principal on RMI's carbon-free buildings team working on building decarbonization policy throughout the country. Thank you so much to the Public Health Law Center for hosting our webinar today, especially Stephanie Lackey and Jamie Long, and to our distinguished panelists for joining us. I'll share more about each speaker as they begin their presentation. Berkeley started a wave of nearly 150 jurisdictions in 12 states across the country enacting building decarbonization policies, recognizing the climate, health, and safety benefits of all electric buildings. These cities, states, and counties adopted policies to shift away from fossil fuels in buildings to clean and efficient electric alternatives. A recent Ninth Circuit court case held that the Federal Energy Policy and Conservation Act, or EPCA, preempted Berkeley's new construction code. Though disappointing, that decision leaves significant paths forward for cities and states who want to reduce and eliminate fossil fuel pollution in buildings. Our speakers will delve into some of the key pathways available for cities and states to move forward on building decarbonization policy following the Ninth Circuit's decision. We'll have each speaker present and leave about 15 minutes at the end for questions. Feel free to add questions in the Q&A box during the presentations. So first we have Daniel Carpenter-Gold. Daniel Carpenter-Gold is a staff attorney with the Public Health Law Center's Climate Justice Team, where he provides technical assistance to community groups, advocates, and policymakers with a focus on equitable building decarbonization. In his previous position at UCLA's Environmental Law Clinic, Daniel submitted 2 amicus briefs in the CRA v. Berkeley case on behalf of environmental and energy law professors. Take it away, Daniel.
So as Denise said, my name is Daniel Carpenter-Gold. I'm a staff attorney with the Public Health Law Center's Climate Justice Team. And I'm going to start things off here by just laying a bit of a foundation about what Denise was just talking about, the Energy Policy and Conservation Act, the federal law that's creating some concerns around building electrification and green building policies, and the California Restaurant Association versus City of Berkeley case. I'm going to roll with it. I apologize. I promise there's nothing important in the bottom right. So to start things off, a quick review of the Energy Policy and Conservation Act, which I'll be referring to as EPCA. So this act was actually passed in 1975 in the aftermath of the 1970s energy crisis. And it focuses on both conserving energy and also, and especially initially, creating additional energy in producing additional energy in the United States. But we're going to be focusing on the appliance efficiency standards that grew out of several revisions to the act in its early years. So basically, what EPCA does is it creates federal efficiency standards for the first time. And so these are efficiency standards that apply to any appliance sold in the United States. And they're the basic things that you'd expect, how much energy your dishwasher can use or your air conditioning unit can use. At the same time, it also empowers the United States Department of Energy, DOE, to take additional action on this front, to either add new appliances to the regulatory scheme, or to enhance the standards that already exist. Now, at the same time that EPCA created new efficiency standards at the federal level, it also preempted state and local standards. So by preempt, I mean it keeps state and local governments from their regulations taking effect with regard to the appliances that EPCA covers. And so the specific language here is that it preempts state and local regulations, quote, concerning the energy efficiency or energy use of EPCA-covered appliances. Now, until recently, this was thought to have roughly the same scope as the federal standards. So if the federal standards said, hey, you can't, you have an air conditioning unit that you can only use X amount of energy, a state can't come in and say, actually, in this state, your AC units have to have X minus 10. Right? They can't make more stringent standards than exist at the federal level. But a couple of, let's say, quirks of the language in EPCA have allowed a theory to be promulgated in the Ninth Circuit, especially 2 points that I want to hit on really quickly. One is that energy use is defined as the quantity of energy that's directly consumed by a consumer product at the point of use, and that at the point of use is going to become relevant. And the other is that there are actually a lot of exceptions to EPCA preemption, so exceptions that allow state and local governments to go through. And this includes standards for flexible building codes or building energy codes. And as we'll see in a minute, that becomes important for how the Ninth Circuit interpreted the scope of preemption generally. So to talk about this case, this case came out of a challenge to an ordinance in Berkeley, California, people are probably generally familiar with, that prohibited gas infrastructure, quote, from the point of delivery at the gas meter, and then applied to most new buildings. They didn't meet certain exceptions. And the case, so the case has a history, but we can skip to the end and say that the Ninth Circuit developed what was a new reading of EPCA preemption. And that is, it proceeds in sort of two stages. One is that appliance bans, so direct prohibitions of an appliance, would be preempted because they, quote unquote, concern energy use by reducing that energy use to zero. And it's also important, as I mentioned before, that the definition of energy use is measured at point of use, which the Ninth Circuit took to mean that EPCA preempts and acts on state and local regulations when they apply to the home where an appliance is going to be used. So again, the idea is that by prohibiting the use of an appliance entirely, it's effectively reducing the energy use to zero. The other point, and the second stage to the Ninth Circuit's reading of EPCA, is that some regulations don't specifically ban an appliance. They don't specifically prohibit an appliance from operating, but they do say they do cut off effective access to an energy source. And in fact, this is what, there aren't appliance bans in the air, right? But there are, as Denise mentioned, regulations that affect whether appliances have energy to run. And that was Berkeley's ordinance, and that was what the Ninth Circuit found to be preempted, even though it didn't directly address appliances, because it had the effect of reducing the energy use of the appliances to zero. But the court immediately recognized that this logic could be extended indefinitely, so that you could end up preempting a lot of things that would be inappropriate and obviously not intended by Congress when they wrote the law. They say, as they put it, that does not mean the sky is the limit when it comes to EPCA preemption. So the question that we have to answer now, and that folks across the country are trying to answer now, especially in the Ninth Circuit, are where does this theory of preemption stop? And the court gives us 2 points to go on here. One has to do with the type of regulation that's affected. So as I mentioned before, the court places a lot of weight on the fact that EPCA has an exception for building codes for new construction. So the idea is that because EPCA contains an exception that specifically applies to building code, that it must be intended to include building codes within its scope of preemption. And in that case, there's a specific focus on the specific type of regulation, and many regulations that state and local governments have to promote green buildings are not building codes. It also, in sort of like drive-by ruling, mentions that direct appliance prohibitions are also probably preempted. So we have the 2 types of regulations that are at the greatest risk of preemption are building codes and direct prohibitions on specific types of appliances. For other types of regulations, of which there are many, the concurrence, so one of the judges that added an opinion to the overall opinion, which doesn't require, other judges are not required to follow, but might turn to in interpreting this opinion. The concurrence suggests that this could depend on whether, quote, EPCA's text or structure suggests any concern with the type of regulation that we're talking about. Again, because EPCA specifically references a building code for new construction and specifically references specific appliances, those types of regulations are clearly within the preemptive scope of EPCA. But other types of regulations that have no reference at all within the text of EPCA should be less likely to be preempted under this theory. The other point that's important to note is the restriction that the opinion places on how it affects different parts of the energy infrastructure. It's very specific about only affecting regulations that are between the gas meter and the appliance that uses the gas. In other words, and here I have on the right a quick little diagram. So the green part of the diagram is running from the gas meter to the label on the right, property foundation. And that means the rest of the distribution, the gas distribution system, which is, all the mains that are running underneath streets, all the service lines that are running up to the gas meter, these are theoretically, and these are actually still within the scope of state and federal regulation, and therefore are not preempted by this approach or by the specific opinion that's brought up here. So I just want to stress the limitations on this reading. And so, first of all, I would definitely say that this is at the far end of the spectrum of potential readings of EPCA's language. I think that lots of folks who had been working on EPCA for a long time prior to this did not see this as a consensus view of how EPCA preemption works. And that's important because this ruling only affects the Ninth Circuit. So I have a map here. The Ninth Circuit is most of the West, Alaska, Guam, the Northern Marianas, and Hawaii. That means the rest of the country is not directly affected. Now, we might move forward and see other litigation, but that other litigation does not have to follow the Ninth Circuit. In fact, we already are seeing litigation in New York. On top of that, there's a very strong dissent to the decision not to take the case en banc, meaning the decision that the whole circuit court, the Ninth Circuit, made not to re-review the initial decision that it made. And that dissent is joined and supported by 11 judges. And it uses very strong language. I've quoted here. It urges any future court that interprets EPCA not to repeat the panel's mistakes. So it's saying, listen, don't look at this opinion to guide you. Look, and then it provides in my opinion, much better and more coherent reading of EPCA that explains why EPCA does not, in fact, preempt these sorts of regulations. So with that out of the way, I want to quickly introduce why we're highlighting the two types of regulation that we're going to be talking about that Jonny and Cliff are going to be going into much more detail on. So the first is Jonny's going to talk about flexible energy codes. As I mentioned in the beginning, EPCA has a specific exception for these types of energy codes, but it does require 7 requirements to be met. And the best way to understand this is that basically the code needs to allow you to meet a certain, it requires builders to continue to be able to use the appliances that meet EPCA standards, that meet federal efficiency standards, and not to have to go lower, more efficient than federal energy efficiency standards at any one point. So to quickly hit on how it does that, first, the flex code has to have a specific energy goal. Second, it can't say that any specific appliance that's covered by EPCA is required to beat EPCA's efficiency standard, so the federal efficiency standard. Third, if a builder decides to beat EPCA standards, decides to use an appliance that has more efficiency than federal standards require, they get credit against other efficiency requirements in the code. Fourth, if they have a baseline design against which proposals are measured, that baseline design does not have any appliances that are more efficient than the EPCA standard. Fifth, that if there's a package, a menu of different packages of measures, there's at least one that does not beat EPCA standards. So there's one that is all the appliances that are covered by EPCA meet EPCA standards but don't go below them, more efficient than them. Sixth, that the energy goal has to be in terms of consumption or cost. And 7, that the test used to measure how much energy an appliance or anything else uses must be the same as the test that the federal standards use. So as I said before, Jonny's going to go into much more detail. The idea that the takeaway here is that you've accepted from preemption if you have a sufficiently flexible standard. Also, Cliff is going to talk about building performance standards. So this is there's been a strong upswelling of support and interest in these over the last few years. These require that all buildings in their scope meet certain declining caps, either on energy use or on the emissions. And the important thing that I'll highlight now is that they are also insulated from EPCA preemption, not because they have a specific exception, but because they don't go within the scope of EPCA's preemption, even under the very expansive reading that CRA v. Berkeley gave it. So because they apply at the building level and not to individual appliances, because they apply to existing buildings and they don't address building construction, they're not building codes. And because at least until the very end of some of the stricter BPS approaches, they don't actually completely eliminate gas use or the use of any appliance. And so, and even the ones that do don't eliminate it for years, maybe decades in the future, which also provides some level of insulation against litigation that would attack those. Those are the two questions. Those are the 2 points and policies that we're going to be highlighting today. I also want to just throw out a few other ideas just to emphasize the fact that there are a lot of options that state and local governments still have to move forward, even under CRA v. Berkeley. And again, outside of the Ninth Circuit, CRA v. Berkeley doesn't directly apply, and people can move forward on all fronts. But these are limits on gas distribution. As I mentioned before, the court specifically said that its opinion does not affect changes to gas distribution, for example, through franchise agreement changes or through service area changes. Fuel standards are potentially protected because all they apply to the building side of the meter. They're not building codes and they're not appliance standards. There's a way of putting appliance standards into the Federal Clean Air Act regulatory program. Again, we can't go into detail here, but this is probably going to see a lot more use, especially in the Ninth Circuit. And policies that don't actually eliminate the use of gas, but strongly promote electrification. Things like emission taxes, flexible upgrades that happen at time of sale, benchmarking, labeling, auditing, and then using those audits to require retrocommissioning or retuning of existing appliances to improve efficiency. So with that, I apologize for how quickly I'm moving through this, but I really want to get on to the specific policy discussions that Jonny and Cliff have. So I'll turn it over to Jonny.
Let me introduce Jonny just quickly. Next, we have Jonny Kocher. Jonny is a manager in RMI's Carbon-Free Buildings program, where he supports states, cities, and counties to adopt cutting-edge building regulations across the country. Among other work, he supported California and Washington states to enact nation-leading energy codes that strongly incentivize electrification. Jonny is an environmental, civil, and mechanical engineer by training and has managed energy efficiency programs for large municipal buildings. Take it away, Jonny.
Thank you so much. Can everybody see my screen?
Yes.
Great. Hi, everybody. Jonny Kocher here with RMI. I've been a manager here for 3 years, and I've been really happy to be working on energy codes and been able to work on ways in which we can move forward with moving to clean heat technology under the Energy Policy and Conservation Act. And I'm looking to get into little details today on some of the lessons that I've learned in California and Washington and Colorado and Illinois, all of which have been a great learning experience. So first, to kind of level set a little bit, energy codes are basically minimum efficiency standards for new and majorly renovated buildings. Some of the examples that are most common in the United States is Title 24 in California. California loves being different and has their own standard, while the rest of the United States typically uses the International Energy Conservation Code, or IECC. Some states, such as Colorado, Washington, Oregon, and New York, have actually adopted state-specific amendments to the IECC mostly to strengthen them. And then ASHRAE 90.1 standard is actually a secondary pathway in the commercial section of the IECC, and I'll get into this a little bit more later on why it's important. Most energy codes are designed based on multiple pathways, and the 2 most common pathways for you to comply are the prescriptive pathway, which is in the performance pathway. The prescriptive pathway is basically a very plain language requirement. You can think of it as space heating systems shall be heat pumps. So it's pretty clear, they define what a heat pump is, then they require it through the prescriptive pathway. A designer must meet or exceed that code requirement. And then some codes require additional energy efficiency, demand management, and or renewable energy targets to be achieved through a credit-based approach. Usually you must achieve a certain number of credits, and then there's a table of credit measures. This approach is designed to be flexible. So basically, you set that energy standard, as Daniel was talking about, and then give a variety of different ways in which you can approach that requirement through the flexible measures. The other approach, the performance pathway, this is requires the generation of simulations or energy models. There's a baseline model that's generated. That baseline model has requirements that are typically set to be equal to the prescriptive pathway. So you can think of it as the designer either has to go through the prescriptive pathway and get all the credits to achieve a certain energy performance, or they must build an energy model that can meet that prescriptive energy performance, or beat it, outperform it. Some prescriptive requirements can be actually made mandatory by requiring that they be incorporated in both the baseline and as designed simulations. And the problem with building codes, both in prescriptive and the performance pathway, is that historically there's been a bias favoring fossil fuel energy use. For both Title 24 and for IECC, there were two separate baselines for historically for a long time. And these were based on fuel type. So you have your electric baseline, you have your mixed fuel baseline. The additional energy efficiency credits that are required through credit tables or the as designed performance models are compared against that baseline for each fuel type. And because electric heat pumps are 2 to 4 times as efficient as their fossil fuel counterparts, a building that uses heat pumps will have a lower EUI or a higher energy performance than that uses fossil fuels. So this creates a gap in energy performance between the fossil fuel and electric buildings. And most of what I'm going to be talking about today is under EPCA's ways to basically like close that gap. And by doing so, we will be making it to where there's no longer this bias favoring fossil fuel energy use, and heat pumps, which are technologies which are more efficient and cleaner, will see those advantages and will most likely prevail when a designer approaches the code. So ways to correct that fuel bias include 3 on the prescriptive pathway approach and 2 in the performance pathway approach. I'm sure there's probably more, but those will be the ones that I'll be chatting about today. And then I'll talk about some final notes to consider about each of those pathways. So on the prescriptive pathway, the first approach one could take is like a field debiasing credit multiplier. This helps reduce bias by just applying a multiplier for the additional credits required for buildings that use fossil fuels. An example of this is actually in the IECC for commercial buildings. It's in the proposed draft, which hope that folks are going to be able to go out there and defend this coming month. It's also in the proposed stretch energy code in Illinois, and props to the New Buildings Institute and their building decarbonization code for mixed fuel buildings. They have the original concept from which both the IECC and the Illinois stretch code were drafted from. There's also a fuel debiasing measure. That's where you set a common credit requirement for all baselines, but then you credit all electric buildings for being more efficient. So you effectively create like a fuel debiasing measure that gives the energy difference between a fossil fuel and a mixed fuel, or a fossil fuel building and an all electric building. There's none to date that we've seen that follow this measure. RMI is hoping to use this measure, this approach in their the EPICA safe code. The one example I can't think of is there was a amended proposal in IECC that wasn't that didn't fully make it into the 2024 draft that we've been looking at. And then there's the fuel debiasing credit table. This approach is what Washington State Energy Code is using, and this basically requires that fossil fuel buildings achieve an additional point in order to eliminate the energy performance gap through an additional energy efficiency table. Kind of getting into what that credit table approach might look like visually. So getting back to that gap in energy performance between the fossil fuel and heat pump building, you can actually reduce that energy gap by, if you like look at this on the graph on the right, or the chart on the right, the blue box basically would require additional energy efficiency credits for fossil fuel buildings, and this will debias the baselines and make it to where the energy performance between the fossil fuel building and the heat pump building are the same. And again, that's the approach that Washington took in this most recent code update. There's also the performance pathway. There are currently two that we've been seeing that use this approach. There's a single baseline approach where you create a prescriptive requirement for heat pumps, and then that is the baseline from which the performance baseline designs must be able to beat. This is what California Title 24 uses, with the caveat that they use something called, they don't use site energy, they use a different metric based on source energy. And then there's a single margin approach, which basically requires the models, both fossil fuel and heat pump buildings, achieve aggressive energy performance targets. And because it's easier for all electric buildings to achieve that performance, it ends up making it to where heat pumps will likely win at the end of the day. And this is where the California stretch code overlay uses, but again, they don't use site energy, they use a source energy metric. Here's a chart on what this kind of looks like. So again, on the left, you have the separate baselines that are required through the performance code historically. And the way in which this has been dealt with in California is that now heat pumps are the baseline from which you compare the performance model to. So the proposed fossil fuel building must now meet that energy performance. And when they do, there's no more gap between the energy performance of the fossil fuel building and the heat pump building. Some final notes, yeah, on the all electric requirement, this is like basically the simply require electrification. This is how Washington had approached it in 2022 and how New York's All Electric Buildings Act is approaching it. I think as mentioned by Daniel, there's a big dissent in the Ninth Circuit case on, so there's reason to believe that outside the Ninth Circuit, folks should still be able to go this route. And on electric readiness, requiring buildings that install fossil fuel appliances to install infrastructure to support electric readiness is a safe approach to both future-proof buildings that still install fossil fuel appliances, but also to incentivize all electric construction now. And it's important when you're doing your readiness measures to think through, do you also want to do energy storage, solar readiness, EV readiness? Because if you're doing those readiness measures, it's good just to make a building that's future-proofed. And RMI did some great analysis on the median cost of EV readiness for multifamily homes per parking space. And this was in support of the Colorado Energy Code, which is an example of electric readiness. The Colorado Model Electric Ready and Solar Ready Code has great provisions in it for both electric readiness, EV readiness, and solar readiness. And the Title 24 Part 6 in the year 2022 also has electric readiness provisions in it, as well as the draft appendix in the IECC 2024 for both residential and commercial. And then a final note on ASHRAE standard 90.1. This is an alternative pathway that's in the commercial energy code. So when coming up with code overlays or amending the IECC, it's important to think through this when looking at the commercial code, because this could be used as a way to circumvent IECC requirements. For example, in the Illinois Energy Code, Illinois Stretch Code, that stretch code it has a legislative mandate to hit a certain EUI target, and they did an IECC overlay to basically hit that target, but they also had to make sure that the ASHRAE 90.1 standard also hits that same EUI target, or else it wouldn't be able to hit its statutory requirement, because there would be a way to circumvent the EUI requirements in the IECC. And that's all I have to present today. I'm happy to answer further questions, and I'm going to go ahead and pass it back to Denise. Thank you.
Thanks, Jonny. And our third and final speaker is Cliff Majersik. Cliff is IMT's senior advisor. He's a pioneer in developing building performance policies and has helped develop benchmarking and building performance standard laws in dozens of cities and states, including New York, California, St. Louis, Maryland, and Philadelphia. And he helped write the bipartisan Federal Energy Efficiency Improvement Act of 2015. He's also the lead author of IMT's Model Building Performance Standard Law, which now serves as the starting point for many state and local bills. Cliff, over to you.
Thank you very much. And thank you all for joining. It's impressive that there's so many people here to learn about ways to decarbonize buildings in the wake of the Berkeley decision. So as Denise said, my name is Cliff Majersik with the Institute for Market Transformation, IMT. We are a national nonprofit with a mission of driving improved building performance as a way to fight climate change and benefit everyone, regardless of where they live, work, or play. So equity is very much part of our mission, and equitable decarbonization is what we're all about. So building performance standards are the most powerful policy for driving change in existing buildings, including decarbonizing those buildings. They're so powerful because they apply to typically all large buildings over a certain size, and they don't require triggers to take effect. So some of the examples of their impact, in Washington, D.C., it's estimated that there'll be a 20% reduction in greenhouse gas emissions from buildings as a consequence of its building performance standard. In Washington State, they're estimating 14 million tons annually of CO2 reduction as a consequence of their building performance standard. And in New York City, just one city, you're seeing estimates that there'll be investments, a market opportunity for improving buildings through 2030 of $20 billion and the creation of 126,000 jobs. So big numbers, and those numbers, of course, would be much larger if you're looking at a national scale. So what is a building performance standard? Well, building performance standards establish successively more ambitious requirements for buildings to perform across quantitative, objective measurements. One example would be reduced site energy use intensity, the amount of energy used per square foot of the building. Another would be reduced greenhouse gas intensity, the amount of greenhouse gas emissions produced per square foot in the building. They apply to a large swath of buildings, typically all buildings over 25 or 50,000 square feet, whether they're publicly owned or privately owned, and regardless when they were built. And they have no triggers that are required to have the laws take effect. So there are preset dates. The buildings must achieve specific measures of performance by a particular year. Usually the first deadline is something like 5 years out from passage of the law. In this way, they complement building codes. Building codes should be designed to set up buildings for success so that they will succeed once they enter into operations and are subject to building performance standards. The two work hand in glove, and they really need to be coordinated. So what is different about building performance standards? Because they apply to existing buildings, they can yield deep retrofits at scale across an entire building stock. They can require that building owners make value-creating investments of their own money in their own buildings. So easier on government bottom lines, budgets. They can require improvement across a wide range of buildings, typically all buildings over a certain size with limited exceptions. And they can provide a comprehensive approach to performance, not just looking at energy or climate, but they can look at other things like water efficiency as well and consider them all in the same platform, making it easier to think holistically about the building. They can balance the need for flexibility to minimize costs with the need for urgent action to fight the climate emergency. And they can send a long-term signal to the market, which is critically important for the market making investment. So where are building performance standards and policies, building performance policies more broadly? This is a map of building performance policies across the United States. The orange jurisdictions have benchmarking and transparency laws. Those are the most common building performance policies. And those orange jurisdictions have laws that apply both to commercial buildings and to multifamily buildings. The green jurisdictions have benchmarking and transparency laws that apply only to commercial buildings and public buildings. And then the purple jurisdictions have policies that include benchmarking and transparency and go beyond that, including building performance standards. So there are now 4 states, Washington, Colorado, Maryland, and most recently Oregon, that have building performance standards. And there are 9 localities, including many of the biggest cities in the country: New York, Washington, D.C., Boston, Denver. In California, the one jurisdiction that has a building performance standard already is Chula Vista. And you have in the Midwest, you have St. Louis has a building performance standard. Now, all of these laws were passed in 2019 or more recently, and IMT advises all of these jurisdictions. Now, the other blue dots on this map are jurisdictions that have joined President Biden's National Building Performance Standard Coalition, which was announced in 2022 and which IMT supports. There are more than 40 jurisdictions that are in that coalition. All are committed they all either have equitable building performance standards on the books already, or they're committed to putting them in place and to collaborating and sharing best practices with each other. So building performance standards are the most powerful policy for driving change in existing buildings. And with great power comes great responsibility. So we need to make sure that these standards are designed in a way that minimizes unintended consequences and advances equity. In particular, whenever you're doing anything, you want to begin with the end in mind. So if your jurisdiction has commitments, whether they be equity commitments or climate commitments, you want to make sure that your building performance standards are designed from the beginning to help achieve those commitments. Social and racial equity is critically important, and we're very pleased that the jurisdictions that we're working with are really centering that. Regulatory fairness, treating everyone, including the building owners, fairly, no arbitrary where one building owner has very little that they have to do and another has very much. Jobs and economic growth are always important. And in order to get that jobs and economic growth, we've seen that you need to maximize certainty. If you're hoping that a building owner will make an investment in a long-lived asset like a heat pump that can have 25-year plus lifespan, you want to make sure that they have visibility 25 or more years out into what their buildings will be required to do so that they can see that that heat pump is going to put them on path to achieving compliance across the life of the heat pump. Transparency so that people can all see how they and others are being treated and see that everything is happening fairly and on the up and up. You want to drive early action because of the climate crisis, because the housing crisis and the need for equity, but also we need to accommodate building life cycle events. That could be things like end of life of equipment, tenant turnover, refinancing the building, which is a great time to get extra money to make improvements to the building at a lower cost. So by accommodating these building life cycle events, we can make it easier for the building owners and less expensive, keep down the cost for the entire economy and help the occupants as well. Of course, with all things, you want to keep your policies as simple as possible, although there are trade-offs that always need to be made. And you want to make it as easy for the building owners to comply and for the governments to be able to implement these laws. So in response to these jurisdictions passing these laws, we had many jurisdictions coming to us and stakeholders coming to us saying, can you help us write our own building performance standard? And so responding to that demand, we created a model building performance standard law, which we published for the first time in January 2021. It's a living document. We're continuously improving it as we learn more about how these laws are working. It incorporates the lessons learned, the good and the bad, from the existing building performance standards that are already in place. We benefited enormously from the fact that we collaborated with expert stakeholders, including government, real estate, social equity, building science, and building performance policy experts who gave us advice, who reviewed drafts, who greatly improved the model law. And now that model law is serving as a starting point for most new building performance standard laws, those that have recently been adopted and those that are pending. The model law is available for free download from our website, imt.org/BPS. So the model law actually has 5 performance metrics: site energy use intensity to drive energy efficiency, on-site and district thermal greenhouse gas emissions to drive decarbonization of buildings, So that looks at how much greenhouse gas emissions are coming from consumption of fuels within the building and from district thermal, and it excludes anything from electricity. So if your building is all electric, by definition, it has a zero on-site and district thermal greenhouse gas emission. And we recommend that jurisdictions look at requiring zero on-site and district thermal greenhouse gas emissions in the longer term for a final performance standard, typically 20 plus years out. Also, water use intensity, the amount of water used per square foot, coincident peak demands, a building being basically a good grid citizen and not excessively straining the grid, perhaps even becoming a grid asset, helping the grid to be more reliable and avoid blackouts, and increasing air quality. Requirements around minimum air quality for existing buildings. So these are what's in our model law, but we work with jurisdictions. Most building performance standards currently only have one metric. A couple have a couple metrics. We'll work with any jurisdiction that's committed to putting in place equitable building performance standards. And we, as part of that equity commitment, we also recommend that there be actions to advance social priorities so that you're really centering community priorities. Often those relate to health, and certainly they relate to anti-displacement. Communities should not be forced to leave their homes. And so these policies need to be designed carefully with tenant protections and mechanisms so that buildings can be improved without excessively passing through costs to tenants or creating loopholes that allow for eviction of tenants. There are also additional equity pieces built into our model law throughout. So one piece at the heart of our model law is the trajectory approach, and this has been adopted by multiple jurisdictions. And what it does is it recognizes that buildings are very different, and a one-size-fits-all approach may not be best. So on the vertical axis, you see building energy use, the energy use per square foot. Going down is better. That represents a building using less energy. On the horizontal axis is time. Today is at the left end of the scale. The final performance standard would be at the right end of the scale. That would be, say, 20 plus years out. All buildings of a certain type, in this case, all office buildings, are required to reach the same level of performance at the final performance period, 20 plus years out. But in the interim, those buildings that start out using the most energy are permitted to continue to use the more energy over each interim period. In this example, there's just one interim period, but typically we would recommend that you have sort of 2 or 3 or more interim periods, usually spaced at about 5 years based on the capital cycle for building owners. So the buildings that start out using the most energy, in this example, building A, are permitted to continue to use more energy, but they have to improve at a faster rate, ultimately all converging on the same point. So everyone has long-term certainty as soon as the law is passed as to exactly how well their building will need to perform 20 plus years out. And that's very important because we've seen that's what's driving investment. Now we know buildings don't improve in straight lines. Building owners know their buildings best. Building performance standards are technology neutral. They don't tell any owner what technologies to use. They let owners decide which technologies can use. This is a hypothetical example of what one building owner might choose to do. So long as that dotted line, the actual performance of their building is below the straight line, that building is in compliance with the building performance standard. And they will decide which technologies and when they will do that. Now, IMT publishes our model law, as I've mentioned. We also have a implementation guide and specific briefs around things like housing affordability and indoor air quality. I'll briefly talk about California because I know we have a lot of California participants on this call. We helped California write Senate Bill 48, which Governor Newsom signed in October, and it requires that CEC come up with a comprehensive strategy for decarbonizing large existing buildings. And that will be due in 2026. CEC is already on the record calling for California to have a statewide building performance standard. And the law basically is nudging CEC to design a BEPS that will not preempt local BEPS. And CEC has a history of encouraging strong local policies, and the California's Assembly Bill 802 provides a good model for a state backstop that does not preempt strong local building performance standards. In the case of 802, that's related to benchmarking laws, but the same principle can be used for building performance standards. SB 48 does require some equity. It requires that CEC consult with affected stakeholders, including community-based organizations representing tenant advocacy, equity, and environmental justice concerns. And the strategy must avoid increasing utility and rental cost burdens for or causing evictions, harassment, or displacement of tenants or covered buildings. And we worked with PHLC and SAGE, you see the quote there, looking at ways to really center equity and tenant protection. Lastly, I'll just mention that there's $530 million in federal money available now for state and local and tribal governments that want to put in place building performance standards or advanced building codes. Up to 9 years and $20 million per award is available. The deadline for concept notes is February 9th, but the good news is they're just 2 pages and there's a template available, so it's not too heavy a lift. And if folks in government who have the authority to adopt building codes or building performance standards want to send a draft of their concept note to IMT, we're happy to take a look at it. There's a link you'll see in the email, and I'll follow up in the chat. There's a link to an IMT overview of this opportunity. Thank you all very much, and I look forward to the discussion.
Great. Thank you so much to all of our panelists, and thank you so much to all the great questions. We'll dig into them now. So we received several questions, both in the chat and from your surveys beforehand, about emissions-based codes. For example, Jim Edelson from NBI asks, will emissions criteria and energy codes conflict with HVAC and water heater equipment emission standards set by air regulators? I'll take a first pass at that. We would say that the safest approach for air regulators to lead on air quality-based regulations. Air regulators have clear authority under the Clean Air Act to set emission standards for sources of particulate matter, ozone, and nitrogen oxides. And air agencies from California to Utah to Texas have already set NOx standards for furnaces and water heaters for decades. As Daniel noted, this authority under the Federal Clean Air Act makes the analysis one of harmonization with EPCA rather than preemption. It might be possible for building agencies or local lawmakers to work together with an air agency to develop building regulations that are grounded in Clean Air Act authority and incorporated in a state implementation plan. But they would need to coordinate closely with the air agency's program staff and council. The safest approach is for the air agency to lead on emission standards. Does anyone else want to jump in with any further thoughts on that? Okay, great. We'll move to the next question. Tom Cabot asks, has IMT worked with counties or community choice energy agency, CCAs, to make model BPSs that the member cities could adopt and have the county or CCA administer? This might help smaller cities adopt BPSs that get centrally administered. Cliff, do you want to take the first pass on that?
Yes, yeah, I think that's a great idea. We have worked around things like Massachusetts Green Communities Act, which is a statewide act, but localities have to opt in. And when they do that, they actually get more money from the state. And in that case, it's has multiple requirements, but one of them is around enforcing a stretch code. There's another good example from Minnesota, where Hennepin County is providing assistance to localities as they're putting in place benchmarking and transparency laws. And we do have some counties, including, say, Montgomery County, Maryland, that have adopted building performance standards. We're in conversation with multiple jurisdictions across California. Some of them, of course, like San Francisco is both a city and county. We have had some conversations with CCAs. I think that's a great idea. We'd be happy to work with folks there. If you look at the map in my earlier slide, there are, I think, like 9 jurisdictions in California that are part of President Biden's Building Performance Standard Coalition and all committed to putting in place building performance standards. So there's a lot of action in California, despite the fact that only Chula Vista has so far adopted a building performance standard. We expect to see more soon.
Great. Thanks, Cliff. Okay, we had a question from Kelly Linden about, can you also address approaches for building electrification policies for municipal housing authorities? And I'll throw that over to Daniel.
Yes, so this is a great question. The Public Health Law Center has been working with HUD, prodding HUD, pushing HUD to, that is the U.S. Department of Housing and Urban Development, to take action that would allow PHAs, that would push PHAs forward, public housing authorities, including municipal housing authorities, forward on their buildings, because they have, HUD obviously has a huge portfolio that they're in charge of regulating. And this is also extremely important for the indoor air quality of folks who are living in public housing and other HUD supported housing, because they have less control, much less control than homeowners over how decisions to be made to protect themselves and their families from things like indoor pollutants, like indoor gas combustion. So this is something that we're definitely working on, and Steph just put in the chat a link to a petition that we've submitted to HUD and that we're pushing, which includes, I think, 29 different regulatory proposals for them to implement. But thanks again for the question.
Great. Okay, we received questions from several folks along the lines of how do we convince policymakers who are nervous to move forward? What can city staff do, and what can organizers do? I'll throw this over to Jonny to start, and then other folks can chime in.
Yeah, thank you. So I think that it's really important to just like show that there are like a menu of options available for cities to look at, and there's like level of risk, and the risk can be like very low to more moderate. And I think like actually having like a layered approach where a city were to pass something that is like very tried and true and has been used and hasn't seen any litigation, and then layering that on top of things that maybe are a little more ambitious is probably a good approach. So, you could pass a code that very clearly falls within the 7-factor test of EPCA. And then if you wanted to do something that that's maybe a little more ambitious than that, then you could also pass that on top of it. So if one thing doesn't work, then you have something to kind of fall back on.
Yeah, I would send people to look at Daniel's blog on this topic. And I mean, broadly, building performance standards, I think, are safe against EPCA preemption. And none have been challenged on that basis. And so steering folks towards, the kind of flexible building codes that Jonny talked about, or building performance standards, and just reassuring them that, those are safe paths that are unlikely to be challenged.
Anything to add, Daniel?
No, I think that what Cliff is saying is exactly right. So their case for BPS is quite strong, and on top of that, as I mentioned before, the CRA v. Berkeley case, the Ninth Circuit's interpretation is, I would say, pretty extreme in terms of the spectrum of possible readings of this clause, and there's going to be there's going to be some copycat litigation to try and expand it, but I am optimistic that future courts will look to things like the 11-judge dissent in that case and discover that they really don't want to follow that approach, because like I said, it's a little extreme and it doesn't really work with either the text or the practical elements of the statute.
We received a few questions about building performance standards and about them being imposed on existing buildings rather than new buildings. I wanted to note that the EPCA provision that discusses the building code exception to EPCA preemption refers specifically to new construction. So I think there's a very strong argument that that there is not that policies on existing buildings would not count as building codes for the intent of EPCA and would therefore not be preempted. So there's a lot of attractive aspects of focusing on existing buildings with building performance standards. But we did receive a question from I think it got answered live just now. We received a question from someone about the political challenges and about political challenges of imposing or of enacting building performance standards on existing buildings and how to overcome those. So Cliff, do you have thoughts on that?
Yes, there's a lot to say on that. I encourage people to go to imt.org/BPS. We will work with jurisdictions to navigate that. Obviously, generally, business doesn't like to be regulated, so building owners often will push back. But if you're jurisdiction is clear that you have a climate commitment and failure is not an option. And you look at the building emissions, typically buildings account for more than half, in some cases as much as 70% of greenhouse gas emissions from cities. It's less so at the state level where you have more rural areas. You work with your building owners, you get them to come to the table. They don't want to have policy enacted without their input. And the message should be that building owners need to be part of the solution. You're open to many possibilities, but ultimately failure is not an option. You need to meet your climate commitments. You need to meet other commitments. And if they have a better solution than the building performance standard, you're ready to put that in place. Well, the reason building performance standards have come about is because jurisdictions have tried lots of other stuff. They tried carrots, they tried incentives, they've tried benchmarking and transparency laws. Those things generally help. They've made a difference. They've moved things in the right direction, but they're just not achieving the level of improvement needed to meet their own commitments and to prevent catastrophic climate change. So that's why jurisdictions are turning to this more powerful policy of building performance standards. Now, definitely, you need to have an equitable process. Frontline communities need to be at the table as you're developing these policies, as well as business and other affected stakeholders. But what we have seen is that over and over again, jurisdictions have been able to get everybody to the table. As long as people are coming to the table to succeed, they say we have a commitment, we have to meet it, and we're going to get there together. And IMT often serves as a bit of a translator between real estate and governments and advocacy and communities to help speak the same language, recognize that there are common goals and that there can be a win-win approach. Because ultimately, no jurisdiction wants to hurt their real estate. Real estate is an important part of every economy. It creates jobs. And there are ways that you can put these policies in place so everyone succeeds.
Great. Thanks, Cliff, and thank you for the question. Okay. Had a question about how can we make these approaches as easy as possible for cities and states to enforce? Obviously, no new hookup ban is pretty clear. How do we make these energy code and BPS programs as easy as possible to enforce? And who would like to jump in on that?
I'll jump in briefly. One thing I'd say is standardization is valuable. I mean, building owners have to comply. Many building owners own buildings in many jurisdictions. To the extent that you can use national model codes, that you can use the kind of codes that RMI is publishing, MBI is publishing, to the extent that you can use the IMT model building performance standard law, and coordinate with your peers. And for very small jurisdictions, it may not make sense for you to adopt a building performance standard, but you can engage with your state, like the state of California, which has a process which will include stakeholders like local governments, and help them to adopt a good law that will help rise all boats.
Great. Anyone else want to jump in on that quickly? No. Okay. We are at 10:30. Apologies, we couldn't get to all of the questions. We will look over them in the chat and try to follow up by email. But thank you so much to everyone for attending. Thank you so much to our speakers again, and thank you so much to Public Health Law Center for hosting. Thank you for attending. We'll adjourn for now.
Sure.